Alrighty, party peoples of the interwebs, it was a lawsuit so ridiculous that even the hyper-partisan Judge Tanya Chutkan had to dismiss it. Viva Fry, former Montreal litigator turned current Florida rumbler, in my home office for a beautiful sunset vlog. Some good news of the day: it was a lawsuit so ridiculous that even Tanya Chutkan had to dismiss it. And if you've forgotten who Judge Tanya Chutkan is, let me refresh your memory, shall I? We'll do that right now. Refreshing happening now.
I'm Ron Burgundy.
Tanya Sue Chutkan, born July 5, 1962, is an American lawyer and jurist serving as a U.S. District Judge for the U.S. District Court for the District of Columbia. She was the presiding judge over the criminal trial of then-former U.S. President Donald Trump over his alleged attempts to overturn the results of the 2020 presidential election, including the events leading up to the attack on the United States Capitol on January 6, 2021. The case never went to trial and was dismissed after Trump won the 2024 presidential election. Early life and education. Chutkan was born on July 5, 1962 in Kingston, Jamaica. Chutkan has a younger brother, Norman, and a younger sister, Robin, both of whom are physicians. And if you ask Robert Barnes, he would say that Judge Chutkan is a communist who has no place on the bench. But setting all that aside, that Judge Chutkan had to dismiss this request for a TRO, a temporary restraining order, that was filed by New Mexico against the Trump administration. And if you had forgotten what New Mexico had done recently, let me refresh your memory on that as well. Shall I do that now? Yes. In September 2023, New Mexico Governor Michelle Lujan Grisham declared a 30-day public health emergency in Albuquerque and Bernalillo County. The emergency order banned carrying firearms in public places and state property in the region. The order was met with criticism and lawsuits. The order was later narrowed and allowed to expire. So yeah, that New Mexico, that Judge Chutkan, and here is the lawsuit requesting a temporary restraining order against DOGE and Musk. Let me read you this. United States District Court for the District of Columbia, State of New Mexico, et al., plaintiffs versus Elon Musk, et al., defendants. Plaintiffs, 14 states represented by their attorneys general, have filed an emergency motion for a temporary restraining order, TRO, against Elon Musk, the U.S. Department of Government Efficiency, DOGE Service, U.S. DOGE Service Temporary Organization, and President Trump. Based on the parties' briefings, oral arguments, and the current record, the court finds that plaintiffs have not carried their burden of showing that they will suffer imminent irreparable harm absent a temporary restraining order, and therefore plaintiff's motion is denied. A request for a temporary restraining order that was so outlandish, even the commie Judge Tanya Chutkan had to say no mas. And at least in the intro paragraphs of this lawsuit, we finally get the answer to what a special government employee is. You know, in fact, we don't get the answer to what it is. I'll show you that as well. But at the very least, we now understand that Elon Musk is a special government employee. On January 20, 2025, President Trump established the, quote, Department of Governmental Efficiency, end quote, and a subsidiary organization, U.S. DOGE Service Temporary Organization, collectively DOGE, by executive order. Elon Musk directs the work of DOGE personnel, but is formally classified as a, quote, special government employee.
You make me happy.
No, not that type of special. This is what AI Grok defines as a special government employee. For those of you who do not know what it is, such as myself, now I know. What is a special government employee? Answer: a special government employee, SGE, is a term used in the United States to describe an individual who is retained, designated, appointed, or employed by the federal government to perform temporary duties with or without compensation for a period not to exceed 130 days during any consecutive 365-day period. The concept is defined under 18 U.S.C. Section 202A and is primarily associated with federal ethics and conflict of interest laws. Key characteristics of an SGE: temporary role, time limit, flexibility, ethics rules, etc. So yes, it is a role that exists under United States law in virtue of an organization that was created by virtue of legitimate executive order, and New Mexico and a bunch of other states were asking for, wait until you hear what they wanted Elon Musk et al. To be enjoined from doing in their request for a TRO. Footnote 2 on page 3. Plaintiffs asked the court to enter the following order: Mr. Musk, U.S. DOGE Service, etc., along with personnel associated with these entities, are ordered to identify all ways in which any data obtained through unlawful agency access was used, including whether it was used to train any algorithmic models or create, obtain derivative data, and destroy any copies or any derivative data in defendant's possession, custody, or control, and that they are temporarily enjoined from A, ordering any change in the disbursement of public funds by agencies, B, extending offers on behalf of the United States that would bind the government to an appropriation that has not been authorized by law, C, canceling government contracts, D, disposing of of government property. E, ordering the rescission or amendment of regulations. F, making personnel decisions for agency employees. G, taking steps to dismantle agencies created by law or otherwise asserting control over such agencies, including, e.g., placing employees on administrative leave. H, accessing sensitive and confidential agency data, using agency data for other than its authorized purpose. I, altering agency data systems without authorization by law or without taking all appropriate protections against cybersecurity risks. Or J, engaging in any other conduct that violates the Appointments Clause or exceeds statutory authority. In other words, New Mexico and the plaintiffs wanted to enjoin DOGE from doing what it was created to do under a lawful executive order from Donald Trump, carried out by employees who were authorized to carry out their functions under the law. That's what the plaintiffs wanted, and they were denied that request. Now, for those of you who have been around the channel long enough, you know that in order to obtain an injunction, you have to show 4 criteria, generally balance of inconvenience, color of right, irreparable harm, and public interest, and the issuance of a temporary restraining order is exceedingly rare under such circumstances, even recognized by the judge, and the judge came to the conclusion that no irreparable harm was showed whatsoever, and here's what the judge had to write on that issue. On page 6 at the end, the court is aware that DOGE's unpredictable actions has resulted in considerable uncertainty and confusion for plaintiffs and many of their agencies and residents. But the, quote, possibility, end quote, that defendants may take actions that irreparably harm plaintiffs, quote, is not enough, end quote. Quote, feared possibilities fall short of the imminent threat of injury required to grant a TRO, end quote. It remains, quote, uncertain, end quote, when and how the catalog of state programs that plaintiffs identify will suffer. But Judge Chutkan, being who she is and being what she is, and that is a commie in disguise on the bench, had to throw a bit of a bone to the plaintiffs and does so at page 8. That said, plaintiffs raise a colorable Appointments Clause claim with serious implications. Musk has not been nominated by the president nor confirmed by the U.S. Senate as constitutionally required for officers who exercise, quote, significant authority pursuant to the laws of the United States, end quote. Bypassing this, quote, significant structural safeguard of the constitutional scheme, end quote, Musk has rapidly taken steps to fundamentally reshape the executive branch. Even defendants concede that there is no, quote, source of legal authority granting DOGE the power, end quote, to take some of the actions alleged here. Accepting plaintiffs' actions as true, defendants' actions are thus precisely the, quote, executive abuses, end quote, that the Appointments Clause seeks to prevent. But even a strong merits argument cannot secure a temporary restraining order at this juncture. So you see what the judge did here is, as she's dismissing the request for a TRO because it's totally unsubstantiated based on hypothetical fears that have not yet materialized, she says, yeah, but you might have a good argument on the Appointments Clause. The irony here is that everything she just said about the appointment of DOGE and Elon Musk is not necessarily true of DOGE and Elon Musk, but it's exactly true of Jack Smith, who never went through Senate confirmation, who was just handpicked as a private citizen to do what you'd ordinarily need to be a special counsel to do, and he just bypassed the entire system altogether and proceeded to the prosecution and persecution of Donald Trump under her ratification. But for the fact that Jack Smith dismissed the charges after Trump got elected, Judge Chutkan would have been more than happy to lock Donald Trump up. A little bit of irony, hashtag confession through projection. Everything Judge Chutkan is criticizing Elon Musk for is truer of Jack Smith, but set all that aside, the conclusion where she says, come back later. Plaintiffs legitimately call into question what appears to be the unchecked authority of an unelected individual and an entity that was not created by Congress and over which it has no oversight. In these circumstances, it must be indisputable that this court acts within the bounds of its authority. Accordingly, it cannot issue a TRO, especially one as wide-ranging as plaintiffs request, without clear evidence of imminent irreparable harm to these plaintiffs. The current record does not meet that standard. Oh, and by the way, before I forget, take 5 seconds to go down and make sure that you are subscribed, that you have notifications turned on, share away because it helps the channel grow. But bottom line, even Judge Chutkan had to toss this TRO. DOGE is going to DOGE, Musk is going to Musk, and Trump is going to do what he was elected to do, what the people want him to do, and that is cut government spending, cut government waste, and have Elon Musk make sure that it's being done properly. That is the vlog. If you like what I do, you know what to do, but most importantly, eat healthy, exercise, sunlight, talk to people in real life, and now you know your vlog. Doge on, boys. Booyah.
Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice.
In other news, today marked the third and final day of a hearing centered on whether special counsel Jack Smith should be removed from Donald Trump's classified documents case down in Florida.
Special counsel Jack Smith dropping his election interference case against President-elect Donald Trump.
Good afternoon. I'm Diane Macedo. We're coming on the air because ABC News has learned special counsel Jack Smith is officially moving to drop the January 6th election interference case against President-elect Trump.